All right, welcome back to the Judicial Proceedings Committee, our voting session, our session 18 and 19. We're going to start off with voting list number 18. And so we're going to start off with Jamie with Senate Bill 57.
Senate Bill 57 expands the definition of crime of violence under 14-101 of the criminal law article to include sex abuse of a minor meeting certain criteria. It also expands the list of offenses that subject an offender to lifetime sex offender supervision to include sex abuse of a minor, which also meet certain criteria and circumstances of second-degree sex offense in an attempt to commit second-degree sex offense as that crime existed before October 1st, 2017. The committee may recall in 2017, second-degree sex offense became second-degree rape. The bill applies prospectively to a conviction on or after the bill's October 1st, 2023 effective date. There is one amendment in your voting packet. The amendment conforms the Senate version to match what passed in the House. That's Amendment 343-823/1. It alters certain provisions for the lifetime sex offender requirements to provide that the defendant would qualify if the defendant was an adult at the time of the offense.
It's going to move the amendment so we can work off of the amended bill, if that's okay with everyone. Second, everyone's good. All right. Now the bill's before you as amended. Sorry, Senator Carter.
Thanks, Committee Counsel Jamie. You gave a good explanation, I think, but I was still trying to pull the bill up. So it expands. Does this, whatever the lifetime supervision expands, is it mandatory or is it something that's under discretion that is reviewed?
Well, so it would be like it's a requirement that the sentence include a term of lifetime sex offender supervision. If you look at, if we're working off of the reprint, that's page 4 of 7. And beginning at line 15. So except where a term of natural life without the possibility of parole is imposed, a sentence for the following person shall include a term of lifetime sex offender supervision. And it's those offenses that are listed there. And let me see if I can find that there is a process for getting off of lifetime sex offender supervision. You just pull that up.
This bill only deals with the sex offenses, correct?
Right.
I mean, the new bill.
So a person, I'm just reading off of the fiscal note, but this is in current law. A person may petition for discharge from lifetime sexual offender supervision after serving at least 5 years of the extended sex offender supervision. Sentencing court must hear and adjudicate a petition for discharge from that supervision. The court may not deny a petition for discharge without a hearing. Further, the court may not discharge a person unless the court makes a finding on the record that the petitioner is no longer a danger to others. Subject to specified exceptions, the judge who originally imposed the lifetime sex offender supervision must hear the petition. If a petition for discharge is denied, the person is prohibited from renewing the petition for a minimum of 1 year.
So it's just first and second degree. Is this limit to first and second degree offenses for sex abuse and abuse of a minor? Or is it beyond, is it taking it further? And I apologize for asking, but I'm trying to get it all together. I don't have a reprint in the computer, but just here. But the purpose of that question is for the persons that this bill would now engulf, what is the period of supervision now as a on the sex offender registry? And this is only dealing with sex offender registry. No, it's supervision.
This doesn't touch the
Supervision, nothing to do with the
registration.
registry.
Right,
This is like monitoring,
right.
GPS.
I'd have to look up the,
Could be, no. So it's like even after your period of parole and probation is over, you'd still continue to have supervision for life.
right, but after 5 years, could petition the court to get off of it. And the court would need to make those findings that they're no longer a danger. I could read that again to you, but
And is the current period of supervision just limited now to the period of parole and probation, or is it beyond that?
I need to double check on that. Yeah. Yeah, that's the is what used to be second degree sex offense. So that's going into so anybody who was convicted of that offense after the effective date of this bill, even though so they'd have to have committed the offense before the 2017 repeal and have been convicted after the effective date of this bill. And there's a constitutional reason why you couldn't increase the supervision on people who were already convicted, because there's some ex post facto issues there. So it's those people who committed second degree sex offense and are convicted after the time that this bill passes that are impacted. As far as what the regular supervision is for non-lifetime sex offenders, Senator, I would need to get back to you on that.
Thanks. I'm not against it necessarily, but I'm always looking for the specific reason for the need to extend it life supervision beyond the first degree most awful offenders. And I'm wondering, once again, is it a bill that's necessary? I mean, is it not something, I can't imagine a court would be quick to say, no, you can't have a supervision period extended for someone that's either non-compliant or someone that is exhibiting an indication of being incapable of rehabilitation. Like, I don't imagine a court would say, nope, I can't extend the supervision, because you can always extend a period of probation for somebody. I'd imagine you could extend supervision for them as well.
Right. Right. And just to note, I know we've been talking about the lifetime sex offender supervision. If you turn to page 3 of the bill, that's the 14101 crimes of violence. So this adds to the definition of 14101 crime of violence. That does have, just for the committee's awareness, does have impact on mandatory sentencing for subsequent offenders. And on page 3 of 7 of the reprint, it would include the offense of sex abuse of a minor under 3602 of the criminal law article. In addition to the current rule where it's a crime of violence if the victim is under 13 and the offender is an adult at the time of the offense, it would also include new language that would provide that it's sex abuse of a minor if the offender is at least 21 and the victim is under the age of 16.
I thought this
this, I mean, one would think, obviously no one wants anyone to suffer from some sort of sexual abuse. It should be an easy bill to vote for, but I know when I look at it, I reflect back to when I served on, after graduating from law school, I clerked at the circuit court. My first day clerking in Baltimore City Court was for sexual offenses. And I remember a number of young men being prosecuted under the law at that time, and with pretty consistent stories of, Your Honor, I was at the club. She told me she was X, Y, and Z age. I did not know she was a youth. And I remember the judge's retort was, son, ignorance of the law is right. And the law provided no defense as to the young ladies lying to the young man about the age. So, I mean, I'm talking 19, 20, 21-year-olds. And them assuming or believing because these actually girls, I can't even say they're young ladies, they're girls, were in these nightclubs acting as young women. And it always stuck with me, like, man, they can be lied to, and now they're messed up. This bill, and what it seems to do is I think some year, I don't know if it was last year or the year before, didn't we put one into the law and we had it at 13? Was that recently?
I think this committee has, well, in the last term, passed some version of this, I think on 2 occasions. I want to say since the 2021 session, maybe. I can double check on that for you. I believe, I'm not entirely certain, but I believe it's this was for the crimes of violence, and apart from the amendment, the same or very substantially similar language to what the committee had considered then.
Because I'm remembering the sense of the conversations where, yeah, you don't need to be violating children this way. But when you're in this certain age range, sometimes it's difficult to figure out what the ages of the young people were that were involved. This line 20 and 21 on page 3 of 7, it bumps up the victim's age by 3 years, and it bumps up the offender's age by 3 years. And I'm just wondering what the necessity of that is when you have on lines 18 and 19, unless there are a number of 14, 15-year-olds that are being victimized. I'd love to hear additional conversation as to the necessity to this bill from this committee, because I'm not sold as of yet.
Check out, can you, while he's, counsel, if you could just explain what like the definition of sex abuse of a minor is, but also while he's doing that, I'd pull up Frederick County's, their state's attorneys, their testimony. I thought it was pretty compelling. And I can read from that after the counsel provides the explanation. Okay.
So 3602 of the criminal article provides the prohibition on sex abuse of a minor. In subsection B of that section, it provides one, parent or other person who has permanent or temporary care or custody or responsibility for the supervision of a minor may not cause sexual abuse to the minor. And B2 is a household member or family member may not cause sexual abuse to a minor. And then the definition of sexual abuse is an act that involves sexual molestation or exploitation of a minor, whether physical injuries are sustained or not, It includes incest, rape, sex offense of any degree, and unnatural and perverted sex practices.
Which is now done. Should be.
New law or the potential new provisions, even the, I apologize for, it's a lot. The provisions applying to the family or household member, are they also subject to this elevation of 16 and 21, or is it still the prior ages?
Are we talking about for the supervision or for the crime of violence?
Yeah, well, yeah, the crime, because you mentioned, you said something about household and family members.
Right. So in order to be sex abuse of a minor, it would need to be a parent or some other person who has permanent or temporary care, custody, or responsibility for supervising the minor, or it would need to be a household member or family member. And those are defined terms that they're defined in existing law for who qualifies as a household member, a family member, a parent. So, right, that's the universe of people who are subject to the prohibition on sex abuse of a minor, or somebody who has permanent or temporary care or custody. So that's sort of the prerequisite. And then as far as being a crime of violence or not being a crime of violence, that's where the age difference between the perpetrator and the victim comes into play.
And the sentence is the 15 years for the second degree?
For the sex abuse of a minor, well, so like even excluding the 14101 like gradations for is it, you know, the first, second, third, or fourth offense, a person who commits sex abuse of a minor is subject to imprisonment not exceeding 25. So then, right, it's you factor in your 14101s, that goes 15. Let me just make sure I'm reading it right. Let's see, subsequent offenders sentenced for a crime of violence under 14101 are generally subject to mandatory sentences for a second conviction of a crime of violence committed on or after October 1st, 2018, sentenced to a mandatory minimum non-suspendable, non-parolable term of 10 years. If the person has been convicted in a prior occasion of a crime of violence. For a third conviction, it's non-parolable, non-suspendable of 25, and then a fourth after 3 separate terms of confinement would be life without parole.
I think you just gave me a plausible compromise, to the extent anybody else is interested in that, which is I could see maybe a second offense, since we already have graduated sentences for first, second, and third offenders and fourth offenders. But I do have a level of discomfort with a lifetime supervision. We already have a lifetime registry, right? Like they're already registered. The registries are public. Everybody can look it up. Everybody knows. If you violate the registry, like if you fail to register, that's a crime. I don't know that I'm comfortable with a lifetime supervision for a first time offense for second degree. Just don't know that it's necessary. It may make us feel like we're cracking down, but in a practical reality, could it be situations when it hurts? And I hate this. I hate the unenviable position of having had so many experiences, like what Senator Sidnor was talking about. You know, within the last year, I remember having a case of an older brother that was like a half brother of a minor, who made allegations about him, and these kinds of things, they rip families apart. Family members are in a position where they're taking sides with one or the other. It affects everything in their lives because the one that's accused is not capable of being in the presence of the minor, even pretrial. And it's very different logistically. And so the situation I'm talking about, it wound up, my case got dismissed. The young man I'm talking about, and the members of the family were very adamant that it didn't happen. The point is that the state's attorney saw fit to dismiss it. Had it actually been something that was provable and they went forward in a situation like that, and the young man would have been convicted, he would have had his sentence that we have under the law, which is already pretty heavy. I just don't know that the lifetime supervision is something that's smart. I think it should be something that in the specific individual case where it's warranted, then there's an appeal made to the court to extend it for a longer period of time or potentially for life. That's my opinion about that.
All right. I mean, it's just the distinction between like an 11-year-old and a 12-year-old and being for the mandatory supervision, which I thought was compelling. But mandatory supervision, it's a thing. I mean, supervision also, apart from registration, supervision means that, you're actively, there's a public safety element there that you're actively being monitored for someone that's dangerous and a threat to others. So,
Can't go anywhere ever, like around any.
Senator Washington.
Being new to this committee and this subject matter, what does supervision consist of?
Yeah.
He's going to read it out of the fiscal note. It's a good question.
If it's in a fiscal note, I can find it.
The sentencing court or juvenile court must impose special conditions of lifetime sex offender supervision at the time of sentencing or imposition of the registration requirement in juvenile court and advise the person the length, conditions, and consecutive nature of that supervision. Special conditions may include GPS satellite tracking or equivalent technology and participation in sex offender treatment programs. Before imposing the special conditions, the court must order a pre-sentence investigation. The sentencing court may adjust the special conditions of such lifetime supervisions in consultation with the person's sex offender management team. A person who is subject to lifetime supervision is prohibited from knowingly or willfully violating the conditions of supervisions. The person is subject to the following penalties for a first offense: max of 5 years and or fine of $5,000. Second or subsequent 10 years and or fine of $10,000. And that's what I've got. I can go into the statute and get additional information if you'd like, Senator, but
No, that's fine. I just wonder what it was. We obviously currently do this and we have the GPS tracker on folks.
Right.
And who's the agency that?
Yes, that runs
that doesn't have to include for monitoring.
the agency that handles it.
Yeah.
I believe that's DPSCS.
And that means,
Department of Public Safety and Correctional Services.
okay, cool.
But it just monitoring. It's a range of levels of monitoring. So it doesn't mean like everyone's on this list has like a GPS on them.
Got it. Okay. And I wonder what's their opinion on the bill or this section, or do they weigh in on these types of bills?
Senator Kelly and then Senator Carter. Let me see.
Yeah, I don't either. Cool. Okay, thanks.
Sorry, I'm also new to the committee and really grappling to understand all the different intricacies here, but also really confused by this conversation. So I hope I am understanding correctly. We are talking about people who were convicted of sexually abusing minors that were in their care. And the question is whether the penalties are the same for people if they abuse both an 11-year-old or a 12-year-old, and then also the 14 and 15-year-olds in different categories, right?
Back there, but let me see if I can address each part of that. So to be subject to sex offender supervision, lifetime sex offender supervision, and we're talking about something that's separate from registration. So I believe these people would be tier 3 registrants, so lifetime registration is required. So that's separate from the supervision aspect, which includes a sex offender management team that does regular check-ins and.
I really want to be clear that
reports.
I'm not misunderstanding the conversation, because I'm kind of sick to my stomach right now. So I want to understand, these people were convicted of sexually abusing minors.
Yes.
Yeah.
So
Okay.
that's why I think that honestly, and this is, I think that the Frederick County State's Attorney frames this very well. It's very simple. And so I'll just read it then, because I was hoping everyone would read it. I think the framing here is very spot on. So Senate Bill 57 recognizes that individuals who are subject to lifetime sex offender registration due to the severity of the sexual offense they have committed should also be subject to lifetime supervision. While sex offender registry is a necessary and beneficial tool, lifetime supervision offers additional protections to ensure that individuals in the state of Maryland are protected from sexual predators. For example, special conditions of lifetime supervision can include restricting a person from obtaining employment that would bring them into contact with minors, random computer checks for sexual activity with minors, and prohibiting a person from contacting the victim or another agent or another category of individuals, such as minor children. Second part, an individual charged with sex abuse of a minor is subject to lifetime registration regardless of the victim's age. So how is it that an individual who sexually abuses an 11-year-old victim would be subject to lifetime supervision, but an individual who sexually abuses a 12-year-old victim would not? Sexual abuse of a minor is a particularly heinous crime in that the offender must have a familial or custodial relationship with the victim. These offenders take advantage of the nature of that relationship and exploit the inherent trust that exists due to that relationship, making them even more predatory. So I thought the framing there is, I think, pretty.
I read that and I appreciated it. And I think it sort of addressed the concerns that were raised by Senator Sidner about a 15-year-old in a club, because this would not necessarily apply in that situation, correct?
But the second degree sex offense,
Can you remind us again what a secondary sex offense looks like when it's committed against a child?
well, so that's also, I'd have to go back and look at the 2017 law, but essentially the elements of second degree sex offense and the elements of second degree rape were virtually the same prior to October 1st, 2017. So, but I believe that would include like those statutory rape provisions, just different conduct. So I could kind of see, I think I'm right about this, that the statutory rape provisions based just on age difference, but without any sort of custodial relationship, just the two parties' age difference would probably fall under what second degree sex offense looked like prior to 2017. So that's a different offense, but it's also included in the bill for the lifetime registration. But what you are talking about is an age difference of either two categories that's going to be subject to. So one, the person is an adult, so they're at least 18 and the child is under 13, or the person's at least 21 and the child is under 16. So there's like two categories of age difference that would apply, but yeah, I think it could include the statutory rape provisions, but caveat, it's with those age differences.
Or a 13-year-old and an 18-year-old. I'm okay with it. Thanks.
Look, I think this is, I know we've talked about it, we've discussed this a lot. This just makes good common sense. This is a necessary bill. This is necessary to have the supervision allowable so that we can monitor, because like we just talked about with streaming of live sexual assaults on minors. I don't understand. This is a necessary bill to protect our children, period. And that way it allows the people within the parole and probation or whatever elements are going to handle it. It gives them the authority then to go in and check to make sure on spot checks. Hey, we need access to your computer. That's not a bad thing. It's just not. When you sexually assault a child and you're convicted of it, you lose that privacy right to be able to go in there and prey on these young people online or in person. And we need to make sure we're doing our part to protect these young kids who are very impressionable, who want to fit in with a lot of older people that they think they're cool, and they're manipulating these young minds to take advantage of them. And I would urge that we move favorable and call the vote. I just said move favorable.
So now. So in looking at the Frederick County testimony, I'm being tripped up by the second sentence where they asked the question, how is it that an individual who sexually abuses an 11-year-old victim would be subject to lifetime supervision? An individual who sexually abuses a 12-year-old victim would not. Both of those victims, they fall under lines 18 and 19 on bill page 307. So what's the distinction that they're talking about that's here in the statute that I'm not picking up?
Sorry, part of the
So it's the second
letter
sentence at the last paragraph at the bottom.
Individual who sexually abuses an 11-year-old victim would not be subject or would be subject to lifetime supervision, but an individual who sexually abuses a 12-year-old victim would not be. So that's, I believe, a reference to the current law. So if you, let's see, we'd be in the universe of 3602.
And while you look at it, just so that everybody is clear to my hesitancy, we're talking lifetime here. And so I don't want to be willy-nilly doing something. I mean, obviously, no one wants any children to be sexually abused, but we're talking lifetime. So I just want to be crystal clear what it is that I'm voting for.
Let me just pull up the existing law. So I was going to try and read 11723 of the criminal procedure article to you as it exists, but it's a little bit confusing with the new language.
Mm-hmm.
So let me just pull that up. But I'm looking at the current 11723A4. So if you're in the criminal procedure article, title 11. Subtitle 7. So I'm looking at 723, which is lifetime sex offender supervision. So in subsection A, that provides that, this is the list of people who are subject to lifetime registration. So currently, the person who has been convicted of a 3602 criminal law violation, which is the sex abuse of a minor,
Mm-hmm.
is required to register, or excuse me, required to submit to lifetime sex offender supervision, but only if the child is under the age of 12.
Okay, so that's
the current law, right?
Okay,
And I think
gotcha.
that's what the state's attorneys were referencing.
All right, and the addition of 20 and 21. That 20 and 21 doesn't address that.
You're right. And you know what? I think I was conflating the two sections, because at the bottom of page 4, that's the sex abuse of a minor and the age differences. For the 3306 violation, all that's required is that the person was at least 18 at the time of the offense. So let me backtrack on what I said about the second degree.
All right, we're gonna table this conversation until the end of this thing. Can you get up to speed on what you need to get up to speed on? And then we are gonna go to the next bill and we'll come right back to it. All right, we're gonna go to Senate Bill 87. Josh, that's you.
Senate Bill 87 establishes a correctional ombudsman in the Office of the Attorney General and specifies the ombudsman's duties. It also establishes the Correctional Ombudsman Advisory Board. There is an amendment in your packet that is number 943926/1. The amendment does several things. First, as in the bill as drafted, the ombudsman is confirmed by the Senate and removable only for cause. The amendment would strike all of that language and essentially make the ombudsman a standard employee of the Office of the Attorney General. The amendment would make a definitional change to clarify that employees of the judiciary are not subject to the ombudsman's oversight. In the bill as drafted, agencies are prohibited from restricting the ombudsman's access to personnel or records. The amendment would simply clarify that they're prohibited from unreasonably restricting the ombudsman's access. The amendment would also strike from the bill the ombudsman's ability to issue subpoenas and to bring actions in civil court to enforce the bill. And finally, the amendment would strike from the bill a new criminal offense that was being created for obstructing the ombudsman's duties.
Can we move the amendment? All right.
Have the unfavorable, the
No.
judiciary.
Judiciary, yeah, that was there.
So,
Employees were not covered under the bill.
all right, so that addresses their unfavorable.
Correct.
Okay, cool, thanks.
So then this largely mirrors what DJS has, right?
Yeah, so
As tightly as possible.
the Office of the Attorney General currently has a juvenile justice monitoring unit who performs somewhat analogous function for the state's juvenile facilities. So part of the idea of the amendment was to bring this more in line with the juvenile justice monitoring unit.
I frankly have no problem even having discussions about expanding the scope of responsibility for this one or for DJS in the future, but those are conversations we have next year. But for now, since we're creating this office out of whole cloth, like, let's start somewhere and then build.
AG's office getting huge.
Motions for favorable? With as amended, the amendment's already been adopted. Is everyone okay? Sorry, Senator Kelly, sorry.
I'm supportive. I just had a question, texted, because I know this is a women's caucus priority and I should have talked to Senator West because I know you're on the bill, right? Am I right with Hedelman? So I know the subpoena power was an issue that they really wanted to keep in and that was struck by the amendment. Is that correct?
I think the intent here is to make this ombudsman as close as possible to the existing ombudsman who takes a look at the juvenile services facilities.
And that
I
does
get
not have
copies of
subpoena power.
that ombudsman's reports. I think it's semi-annually. And so this ought to be just like that. And as the chair said, next year, if we want to beef up the responsibilities of each one consistently, preferably, we should do that next year.
And yeah, no, I understand the idea of phasing that. I just want to make sure because I'm clear here that, so there's no subpoena power in the current one that we're modeling this after. And that's one of the issues. Okay,
Although they both want it. But
right. So the discussion we will continue.
Yeah.
And then the other question I had was just how many staff are now going to be, I'm looking in the amendment, does that change the staffing levels?
The amendment did not change
Okay.
the uncodified language on that.
Okay, great. Thank you.
All right, so there's been a motion for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right, excellent. Everyone's a little unhappy on that one, so it looks like we did some good work.
Progress in this area. It's been a couple of years, like at least 3, I think, that we've seen this. So I'm happy that we're doing something. And we can let them come back next year and tell them how it's not enough and we have to do more.
All right, let's go ahead. We're gonna do Shamari. We're gonna go to Senate Bill 400. So I think we're doing this as a summer study. We're trying to bring the folks together in a more intentional manner so that they can come back next year and we can finally get rid of this bill. And no, this is Senate Bill 400. Go ahead, Shamari.
Senate Bill 400 requires all motion picture houses to offer closed captioning for each screening of a motion picture. And it requires that a place of accommodation that controls, operates, owns, or leases at least 2 motion picture houses in the state to provide open captioning for at least 2 screenings each week for each motion picture after the first 7 days of release.
To interim summer study.
All right, so the motion is it a motion I make? Is it a motion?
It's, yeah, so the motion would be re-referred to interim summer study.
All right, so the motion is to re-refer to the interim summer study. Can I get a second? All right, is everyone okay with that? Excellent. All right, now we're gonna go up to Josh again. This is Senate Bill 459. You can read the bill, but this is a sponsor request that we do the same thing, summer studies, but go ahead.
The bill requires specified training for personnel involved in the supervision and care of individuals placed in restrictive housing and for hearing officers, and establishes requirements and limitations relating to the placement of individuals in restrictive housing.
All right, summer study motion. Everyone's okay being recorded in the affirmative? Excellent. All right, sweet. Yeah. All right, why don't we summer study? Senate, so let's go Shamari again with Senate Bill 485.
Senate Bill 485 requires that a contract for sale of residential property located within a half mile of a Superfund site include a notice of the proximity of the property to the Superfund site. There is an amendment in your packet that limits the bill to Frederick County, and instead of notice requires an addendum with a signature from the seller and the buyer. And it allows a buyer to rescind the contract of sale and receive money back if they don't receive the required addendum. There is a delegation letter that didn't make it to your packet, but there is a delegation letter from Frederick County.
This is a Superfund bill. It just deals with, and within a half mile of Superfund areas, i.e. toxins that Fort Detrick had buried in the ground during World War II. Those canisters broke open, they leached in the ground. We just want them to, within a half mile on new home sales, they're already required on resale, that they have to put a disclosure out there that these people understand that they're buying in an area that's could be affected by the Superfund area.
All right, we do have one amendment in the packet and the delegation letter supports the amendment. So Mark, could you just explain the
so
amendment?
just the amendments limits the bill just to Frederick County. And instead of a notice, it just clarifies that an addendum, it should be an addendum that's added to the contract of sale, which would require the seller to disclose the existence of the Superfund site within a half mile of the property.
And then it also has it left in there their right of a 5-day right of rescission.
Right of rescission if they don't receive the addendum to the contract, and they should get their money back.
Well, the problem is I don't know that's, if they don't receive their addendum and they've already done it, like it's required that they do it. If they find out anytime and they weren't provided with that, I don't know why that language would read that way. The language is supposed to be very specific, that a required addendum on their packet that discloses that it's within a half mile of the Superfund site. And that's when they have their chance for right of rescission. My understanding was not that if they didn't disclose it, it gives them right of rescission, because that's kind of.
So this is how it reads, Part D. If a buyer enters into a purchase or construction contract does not include an addendum required under subsection B of the section, the buyer may void the contract, and on rescission of the contract shall be entitled to a refund of any money paid to the seller or builder.
So it doesn't have any time frame on the rescission. Okay, good. If they have it on there and that's fine. Right now, we just want the addendum on there to make sure they're doing their job. Thank you. No, because if you put it in and then they don't disclose it and it's outside of 5 days, they have no recourse. Right. Well, it's supposed to be on the addendum.
Yeah, I know. I got it. Senator McKay, then then Senator Sidnor.
So first question is National Priorities List Superfund site. Do we know how many national property list Superfund sites we have? No, I understand that, but statewide, is that?
This
I
is
mean,
a
I know-
statewide bill.
I understand that. However, I want to make sure that the Superfund site that I have in Cumberland, you put this in Cumberland, you are going to forever have dilapidated buildings. They will never be sold. County will have to spend more tax dollars to raise them. I'm dealing with blight left and right, and I just want to lock it in as hard as I can. I understand that. I got a friend who owns a house right there. His property value is going to drop, but that's beside the point. But I want to make sure that this does not go statewide
It's
because I'm
not.
already dealing with blight in Cumberland.
That's why we restricted it down to just Frederick County.
Okay.
There's 26 around the state.
There's 26 of them. So
It'll give you
yes.
cancer, but go ahead and build. All right, Senator Sitnor.
Would you mind, are you able to note which counties have these super funds?
There's a list published. I can pull it up. If you give me a minute. Oh,
It's 26.
there's 26 around the state, yes.
Any in Baltimore County?
Um,
I mean, now that we've made it a local bill, it's like, I mean, it was brought up as a state bill, and I'm like, all right, that sounds good, but now I'm.
Everywhere. Look, former dry cleaning.
Oh, yeah, go.
Senator Cage, chime in and then we'll go to Senator Washington.
No, as a former dry cleaner, super funds are all different. And so one of the things with dry cleaning, perchlorethylene is actually a sinker. So when it rains, it's heavier, so it goes deeper into the ground. So you really don't get affected by it. It gets into the water table, which is a problem. But it is different. Super funds are different, where the conversation was about if you're going to build in that area, or you're going to get sick or whatever. That type of a super fund, you're not going to, because it's going to move down the road. CSX, having plenty of tracks and warehousing and all that kind of stuff, their super fund is their sites, as I see it, are much different, that they're not as much on the toxic standpoint as they are as, do you want to be playing in the yard that only has 18 inches worth of soil covering it up? So there is a difference. All I want to do is support Frederick County, but I don't want this to open up. There's already 32% of the city of Cumberland we're over housing stock, and it's all dilapidated. And
Adversely affects you all?
what I'm
This
saying
motion?
is, if you in the half mile radius, if that has to do it, then there's going to be less of those homes being sold.
Thank you.
That's a fascinating issue. I definitely, I didn't know that. So, I'll do some research on Superfund sites. Seriously, Senator Washington. We'll get let's see how many are in Prince George's.
well, I was 3 in Prince George's. Hartford has 3. Looks like Baltimore County has 1.
Well, look. I was just gonna ask.
None in
if-
Montgomery.
Is my mic on? Yeah, I was gonna ask if I was gonna ask first for a study to see like how it works in Frederick County, like how's it doing, or if it's actually working. But then I thought about it. We just had a bill on the floor where it said Eastern Shore senators, and they weren't all supportive. So I'm wondering if the Frederick County senators have a letter of support for this. Okay, cool. All right. Well, I support it. I just really would like it for the 3 sites in Prince George's.
But let's do this. Let's do this. Let's keep this bill just Frederick for now. Yeah, just let's keep. Yeah, no, seriously, I don't, because, yeah. All right, so it's, the bill is before you as amended. Is a motion for favorable? Seconded, seconded. Is everyone okay being recorded in the affirmative? Yeah. All right, excellent. It's a good discussion. So is that for real? The Montgomery County doesn't have any?
Not seeing any listed.
I don't believe that. You believe that? No, we absolutely cannot move any from any other jurisdiction to Montgomery County. All right, we're gonna go Senator Carter with Senate Bill. This is Shamari again. Senate Bill 770.
Senate Bill 770 allows a tenant to file an action for injunctive relief, a temporary restraining order, preliminary injunction, or damages if a landlord illegally locks out a tenant or willfully diminishes services. And so you do have a amendment in your packet.
So look the bill, right? This is part of the state. Just look. Should be a Baltimore City.
Yes, it is a Baltimore City bill. And there's a delegate, I believe there's a delegation letter, may not have made it into your packets. But amended, it applies the bill just to Baltimore City. And yes,
You gotta adopt the amendment. Can we move the amendment? Is everyone okay? Sure. All right, so now the bill's before you as amended. Senator Walsh-Reicher.
Listen, it's a delegation bill. I'm happy to support and defer. I know there was substantial opposition at the hearing. Do these amendments assuage the opposition to the bill?
I think so. I think they tighten up the circumstances and also specify, they specify like, of course, the landlord lobby was concerned about abusive tenants that use this to get over. And I think the language kind of tightens up on that. Would you agree?
and yes, and it does, it strikes a portion of the bill, if you look on page 2 of the reprint. And just really just limits it just to the landlord taking possession of the dwelling, and that it has to be in accordance with the warrant of restitution, and only if the tenant surrendered or abandoned possession of the dwelling unit. And so the justification that was given was that this is going to be a quicker process. The hearing has to be scheduled within 7 days. And so this is just a way outside of the criminal process for tenants to get some relief if they do get illegally locked out.
All right, now the bill's before you is amended. There's been a motion for favorable with the amendment. It's the second. Is everyone okay being recorded in the affirmative? Yes, excellent. All right, Senator Carter, we're going to come back to Senate Bill 759, but let's keep moving on. I want to go to Senate Bill 9. This is Josh. This is Senate Bill 917.
Senate Bill 917 authorizes specified officers of a volunteer fire company and fire police of a volunteer fire company to equip their privately owned vehicles with red or red and white lights or signal devices in accordance with existing provisions of law relating to the use of such lights.
Motions for favorable. It's been seconded. Is everyone being okay being recorded in the affirmative? All right, Senate Bill 917 passes unanimously. Now we'll move on to Josh again, Senate Bill 927.
Senate Bill 927 establishes a committee on rate setting and complaint resolution for police initiated towing within the Department of State Police to recommend approved rates for police initiating towing and recovery services and to perform other duties. The bill also requires state police to establish the approved rates and by January 1st, 2024, and alter certain provisions that establish an effective date for when an authorized tow company must accept certain payments for the release of a vehicle. So the House cross file has passed the House with a couple of non-substantive amendments. The third reader version is in your packet if you want to take a look. So the House amendment simply clarified the name of the committee to better reflect the work it does, and it removed a redundant provision relating to staffing of the committee.
Yeah, move the amendments. All right, everyone's okay.
I guess the motion would be to conform
To the House
bill.
version. Is that the motion? All right, everyone's okay. All right. It's amended. Now the bill's before you. Go ahead. Further discussion. Motion for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right. Senate Bill 927 passes unanimously. Now we'll move on to Senate Bill 944. Shamari.
Senate Bill 944 requires that by July 1st, 2023, the Maryland Historical Trust terminate or extinguish the easement dated June 28th, 2010 in the parcel of land known as Warner Manor, granted by Montgomery County, Maryland, and that they complete all necessary recordings and filings to complete the termination.
So motion for a favorable, it's been seconded. Is everyone okay with being recorded in the affirmative? All right. Now we'll move on to Senate. This is Jamie. Senate Bill 126. Are you ready for that? Or are you right? Senate Bill 126.
Senate Bill 126 modifies the eligibility requirements for a person to be certified as a law enforcement officer by the Maryland Police Training and Standards Commission. It repeals the requirement for an individual who is a permanent legal resident of the United States and honorably discharged veteran of the U.S. Armed Forces to have applied to obtain U.S. citizenship with a still pending application. And it also repeals the requirement for the Police Training and Standards Commission to terminate the commission of a police officer who fails to obtain U.S. citizenship. So essentially what this does is it says that if the person is honorably discharged from the U.S. Armed Forces, regardless of whether or not that person has a pending application for U.S. citizenship, they are eligible to become certified as a police officer, assuming they meet the other requirements. They just wouldn't need to meet the citizenship requirement of police officer certification.
Hey, look, let's have an open.
They can serve in the military presently, but they cannot automatically serve in the police. Is that correct?
That is correct. So actually, this changed, I
Okay.
believe, in 2020 or 2021.
God, I just don't understand it, and
Right.
I'm for the bill.
All right, Senator Bolden.
The difference between serving in the military and serving as a police officer is one, you have the right to take someone's freedom away. The other, you don't. And you must be able to, and the irony is that you could be, as this is done, because now it's cutting out provided that the individual has applied to obtain United States citizenship and the application is still pending approval. So that's one of the elements that when they serve in the military, that they were a pending citizenship. And then if this bill just says if they got out before that got ratified, that it still needs to be in the process and it needs to be passed. And this bill would say, no, we're not worried about it. You can police our country's laws, but you don't have to even be a citizen of this country or in the process of becoming a citizen of this country to take away citizens of this country's right of freedom. The very fundamental that everyone wants to come to this country on, the right of freedom. And we're going to allow people that are not in the process to become citizens to take away legal U.S. citizens' freedom away. Think about that.
I'll tell you this, I really did. I thought the other bill we passed, like 2 years ago, maybe 3 years ago, was controversial at the time, but I liked it because it had a pending application and like you've been honorably discharged. You know,
Right?
No, that's left to double check.
Did they leave that in?
I think it does require an honorable.
Oh, yeah, it
honorable
does.
discharge.
It does. It does.
About the bill. So the bill that we passed before, did we passed a precursor to this, or did we not?
Remember, you had to be honorably discharged and then you could have a pending application for citizenship.
And that makes sense. So let me just say, when we talked about 2 years ago extensively, the need for police reform, one of the major themes of that was this militarization of police. Chairman Smith himself has taken it as a personal mission to year after year come back with reporting on military equipment. But militarization of police is not limited to equipment from the military. It's a mentality that comes from the military. And so I have a concern that people that aren't from here, that come from the military, not part of like in Baltimore City, we already have a real problem with people that are born here and are citizens that don't live in the city and don't understand the culture of the city and are uncomfortable with the people that they are charged with policing. I think this is a step in the wrong direction until we get police agencies straight. I wouldn't add this layer to it. That's just my opinion. And I think the fact that we said honorably discharged, like, isn't that pretty significant?
There's like a strange vortex forming that Senator Fold and Senator Carter are on the same side of an issue. So that's a sign from the universe to me for me to just hold this bill for now. Okay, we're gonna move on to Senate Bill 192. You guys need to hang out a little bit more. I don't know.
Senate Bill 192 establishes requirements, procedures, and prohibitions to govern the use of facial recognition technology by law enforcement agencies in the state.
Sure, thank you very much. As a number of you know, I've been working on this legislation for a number of years, and we keep getting closer and closer. And there's been some give and take on both sides. In my opinion, probably my side giving more than giving or getting. But regardless, the House has passed the initial bill that you all saw with a number of amendments. And if you have not seen the House Bill's amendment, what they essentially do is they increase the number of crimes that facial recognition can be used for, which honestly, after having much conversation, I'm not necessarily opposed to that. So the bill that is going to come out of this committee will likely have some changes. They're increasing the number of crimes that can be that facial recognition can be used for. There was also and has been a lot of debate around the databases that can be used by law enforcement with facial recognition. The initial bill language that I put in restricted the database to driver's licenses, mug shots, and driver's license and mug shots or similar databases of other states. I did this because when I first began working on this type of legislation, that's what I was told were the images that law enforcement were using. However, one of the arguments from law enforcement has been that they now go beyond that. When you talk about what happened on January 6th, they use services that go beyond those general government databases, and they found them to be effective. I hesitate with that, but I think I can get there. However, there are some organizations or some companies that have been written about extensively because of the way or the manner that they created their databases. They created their databases by going on to social media, and they've been accused of scraping people's photographs off of social media against companies' policies and then using that to build their databases. I've explained to Scott Schellenberger that I don't believe that companies that do this should be rewarded for what I believe is their bad behavior. So while I believe I'm open to expanding the database that law enforcement uses, we're working on language that is going to ensure that if we're working with companies that are violating social media policies, that those kinds of companies, it could be considered a breach of that contract that one would have to enter into to engage that company. some of the other, I think one of the other things that was struck over in the House bill, there was something that we talked about, proficiency testing. I'm looking to put proficiency testing back in. That's essentially to ensure that people who are using these databases, they have the proper type of training, and the databases themselves are being tested and the like, because but a number of if you were to go online, you would find a lot of research that talks about these systems and a lot of the flaws that the systems have. I see a lot of promise in their use, but I also understand that there are a number of downsides in facial recognition. But I think the benefits outweigh some of the downsides in law enforcement's use. One of the other changes that you'll see, I think when I first put the bill in, we had the Department of Public Safety and Corrections kind of being that go-to organization that was going to develop policies and training and host different reports and things. They've asked to be out. The state police, I think there have been conversations with law enforcement and state's attorneys that the state police might be the better agency. And from my conversation with the state police, I think they're fine being there as well. So there was also some discussion, and I cannot recall the exact page, but there was some additional language that was put in that I know that the Office of Public Defender and Common Cause were concerned with regards to Brady information. So I think there was some additional language that state's attorneys had put in that would have restricted certain information, or the effect would have been it would have restricted certain information from being disclosed if there were not hits or whatever. The idea is if we're going to be using this system, we want to know how well your facial recognition systems are working. So the suggestion that I'm going to make on our side is that we make certain that we know everything with regards when a search is made, whether or not they got a hit or not. I think we need to know what happened, what transpired. And finally, I believe, let me see, what was the last thing? I cannot remember the last thing I was going to say, so I'm going to stop there. But I think we're close. We're very close, but I do think that some changes need to be made to the House's bill.
Yeah, let me just do this real quick. So just, do you want to conform to what the House did and then work off of that? Or what is your suggestion?
I think we can do that and begin to work off of that.
So then if we do that, it's going to require just, we'll bring it up the next time we vote.
Sure.
But you're fine with conforming?
So long as, again, we'll get the things in mind, so it will be amended, and then that amendment will be amended.
You amend the House and the Senate version at the same time?
Sure.
Okay. All right. So just the motion to conform to the House version. All right. Excellent. So we'll come back with whatever language you come up with. Okay. So we've done that. That conversation is now tabled. We're going to move on to Senate Bill 759. I think we've gotten through everything else on the list. That's Senator Carter, and I don't know who the counsel is for 759. That's yours. Yeah, it's yours. Yeah, it's not on the list. It's the last. Who's the counsel? Josh.
Forced separation for pregnant women in prison.
There's a couple of amendments because the Women's Pre-Release Center is not a thing yet. So I think, Josh, can you offer some, I mean, you're not offering it, but can you give us some language that would address the fact that the triggering event would be when the pre-release center is actually up and operational?
I think that the easiest way to do that would be simply to make the whole bill contingent on the opening of the pre-release center. Except for
I don't know about the whole bill, because I think the part of the bill that requires them to be in the pre-release center, but up, like if it takes 5 years to get that up and running, there ought to be provisions of the bill that can apply now before that center is there, in my opinion.
There's no harm, but right? It's not built within 10 years, there is harm because they're going to be somebody who is.
Well, there,
Can we bring some next time we go on Monday?
yeah, and I'll work on it in the meantime.
All right, so we're gonna hold that bill. No, I get it. All right, so now we're real quick. And this is, so now this is Senate, this is voting list number 19. Now, I want to be clear, the intent is to move unfavorable on every bill on this list. But if you need to be recorded in a positive for your own stuff, let me know, and then we can do one by one.
I'd like to be recorded in the positive on my city bill, please.
All right, Senate Bill 767, Senator Carter is recorded in the affirmative. I hate that bill.
It's, the motion's unfavorable.
So she's no on the unfavorable. Yes, okay, I got it.
He did withdraw it, so it's WDR for his.
Favorable on, but you haven't brought it up yet, so can you hold that I'm favorable to?
Yeah. Sure, yes,
State attorney's bills are cannot be dealt with.
got it. No, yeah. That's not on this list, though.
On the remaining,
Those are just coming out of.
on the remaining six?
Yes,
Can we move unfavorable?
yes. Do you want to be recorded on no on the unfavorable for Senate Bill 43? Okay. Yeah. You're gonna be, okay, and then same thing with Muse, and then everyone else is okay being recorded
Yep.
on yes on the unfavorable for all these.
Yep.
All right,
So Muse
and
and Carter are no to the unfavorable 143.
then Senator Sidnor is gonna be no on the unfavorable for Senate Bill 110. All right, Fiona Apple, don't be mad at me. All right. Ooh, that's a call to arms right there. Shouldn't have said that on mic. Whoops. What? All right. All right. All right. So just so for the record, Senate Bill. Senate Bill 43, 110, 123, 165, 427, 532, 767, and 956 have all been reported out of the committee as unfavorable. All right, congratulations. We're done for the weekend.
I got Washington.